behalf of the defendant Gregory Ryden, who is not present, and when he does appear, Your Honor, I do need a moment to go over this plea agreement and have him sign it.
Okay, did we already go over, did we do the competency review?
Yes.
And are they bringing him up?
You bring him out, yeah, he's already up.
Okay. Let's go off the record, let me know when you're ready.
Thank you, Your Honor. Just like I'm ready if I can approach.
You ready?
Thank you.
Sir, please raise your right hand. Do you swear or affirm or we're right back in the record. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you had enough time to speak with your attorney?
Say it again?
Have you had enough time to speak with your attorney?
Yes, I have.
Have you taken any medication yesterday or today?
Yes.
And is it medication that helps you think more clearly?
Yes.
And is there medication you're supposed to be on that you are not on?
No.
Do you have any sign of fever, COVID, or other illness?
I know that.
Counsel, you've had an opportunity to speak with your client. Do you believe he's oriented to date, time, and place, and does understand what's occurring today?
Yes, Your Honor.
All right, I do as well. He's been able to answer questions appropriately, has good eye contact and body language. Sir, are you a U.S. citizen?
Yes.
And were you on probation, parole, or bond conditions before another judge at the time of the event you're pleading to?
Can you repeat that?
Yes. Were you on probation or parole at the time of the event you're pleading to?
No,
Were you on bond conditions before another judge at that time?
2 years later, yes, I was.
But not at the time.
But not at the time, okay, very good. On behalf of the people, what is the plea agreement?
Thank you, Your Honor. The agreement in this file is for the defendant to enter a guilty plea as to count one. The people have agreed to dismiss file 22-1553 SM out of the 55th District Court. There is a sentencing recommendation that the defendant shall serve just time served at the time of sentencing. And there is a stipulated restitution of $953.08 to be paid to the Clarion Point Hotel. $15,907.58 to be paid to the Lansing Catholic High School.
Is that full, fair, accurate, and complete, counsel?
Yes,
Sir, is that full, fair, accurate, and complete?
Yeah,
And counsel, you are waiving reading then of the dismissed or the file, what will be dismissed, 22-1553 SM?
yes,
All right, as to count one.
Thank you, Your Honor. People of the state of Michigan versus Gregory Ryden, case number 4-453 FH. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before this court and informs this court that on or about July 14th of 2022 at 501 Marshall Street in the city of Lansing, Ingham County, the defendant did in count one malicious destruction of a building, $10,000 or more but less than $20,000. Did willfully and maliciously destroy or injure a building or its appurtenances located at 501 Marshall Street, Lansing, that belongs to Lansing Catholic Central, and the amount of destruction or injury was $1,000 or more but less than $20,000, contrary to MCL 750.3803A. This being a felony punishable by up to 5 years and or $10,000 or 3 times, the amount of destruction or injury, whichever is greater. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition, if not taken at arrest. This being done against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
yes,
So you understand count one, malicious destruction of building, $1,000 or more but less than $20,000 is a felony punishable by 5 years and or $10,000 or 3 times the amount of destruction or injury, whichever is greater. You would also be responsible to pay restitution, and that amount has been agreed to. And that is contained in the plea agreement as stated by the people, $953.08 to Clarion Hotel and $15,907.58 to Lansing Catholic High School. Is that your understanding?
yes,
All right, very good. And it looks like you signed the advice of rights form. Did you read it before you signed it?
yes,
Did you understand what you read?
I understood,
And if you had any questions, you were able to have them answered by your attorney?
yes,
And you also understand that by pleading, you're giving up your automatic right of appeal. If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal. Had you had a bench trial or jury trial and you are unhappy for any reason, they must take a look at your unhappiness. But now it becomes their choice once you plead. Do you understand that?
I understand,
All right, as to count one, malicious destruction of building, $1,000 or more, but less than $20,000, how do you plead?
guilty,
And sir, other than the plea agreement, has anyone told you what I will do at sentencing?
yes,
Well, let me say it this way. No one could tell you what I will do at sentencing because I don't even know. However, you do have a plea agreement, so you know some of what will happen, which if I violate, I will allow you to withdraw the plea. But if you violate the law, then I don't have to allow you to withdraw the plea. Do you understand that?
yes, I understand,
Okay. And have you planned of your own free will?
Yes,
And you understand that if you didn't plead of your own free will, you need to let me know that now, because if you come back later and say, Judge, I shouldn't have pled, I don't have to accept that. Do you understand that?
I understand.
And you pled after you discussed it, whatever you wanted to with your attorney,
Yes,
and you've been satisfied with the representation of your attorney?
I have.
Sir, did this offense occur on or about July 14th, 2022?
Yeah,
In the city of Lansing County, Bingham, state of Michigan?
yes,
At a specific location known as 501 Marshall Street. That is a building,
yes, the building.
and you were at that location,
I was,
and that belonged to Lansing Catholic Central High School.
yes,
And did you destroy or injure parts of that building?
yes.
What did you do?
I broke windows.
And you didn't have any right or entitlement to be on that property or to destroy it, did you? There's no ownership, correct?
Correct.
All right. And counsel, just for clarification, the Clarion Hotel, is that from the other file?
Yes.
Yes.
Okay, all right. And would you agree, sir, that the amount of damage was approximately $15,907.58, the amount you agreed to pay in restitution, which means that it's more than $1,000, but less than $20,000?
Yes,
All right, on behalf of the people, any additional questions?
No, Your Honor.
No.
Counsel? Thank you. Our counsel were promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No.
This court complies with the court rule.
Yes, Your Honor.
Yes.
I find defendants pleased when freely, voluntarily, knowingly, and understandingly made without undue influence, stress, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count one will enter on docket 24453 FH. The 221553 SM file is dismissed. However, restitution will transfer over onto this file. Any outstanding warrants as to both files, if any, are hereby recalled and dismissed. Do we have a sentencing date?
January 21st at 10 a.m.
Does that meet with your schedule, counsel?
Yes.
And sir, do you still live on Kensington Road?
no,
Do you have a place to reside?
yes,
Where is that?
city rescue mission.
Okay, so you're homeless at this point?
Yes,
All right. All right, sir, while you are in jail, probation is going to come and see you. They're going to do a very detailed pre-sentence investigation report that we'll talk about at the time of sentencing. I'm going to ask that you work with community mental health and anybody else who is available, so we find you housing other than the rescue mission. They're at capacity. I don't know if there's bed for you or not. So hopefully between now and then we can find some options for you. Are you generally employable, or do you have SSI or SSD?
I don't, and I'm not employed.
Have you ever been employed?
Yes,
What do you do?
I have done some minor restaurant work.
Okay.
I worked in some factory jobs, and I worked in dry cleaning service.
Okay, good. So let's work on all of that, getting all of that together for you while you're incarcerated, okay?
Yes,
And you'll continue to work with community mental health and any other services we can provide.
yes,
All right, and you'll continue to stay in your medicine.
Yeah.
All right, anything else for the record?
Not from defense.
Nothing for the people.
Thank you, that's all for this record.
Hi, Judge, how are you?
Nice to see you, are you back?
Yes.
back and rocking and rolling, well, not back in this quarter, but I'm back,
No.
I'm back rocking and rolling.
All right, well,
I am here for Jamon Walker, and we had agreed, Mr. Silverthorne and I, to adjourn. We need to get a new PSI.
Okay.
So I just want to make sure that that is.
are we getting an updated or a new one?
I'm sorry, updated, just updated.
Okay.
It's like from 10 minutes ago.
So we can just put it down in the court note. Do you have a new date?
It's probably not.
January.
We want to do it probably like as soon as possible. Oh, let's see, he just says I'm in court. No, you're not.
Different court.
Yeah, January 7th.
We have January 7th at 10. Would you like that date?
I'm sorry.
January 7th at 10, and who's his attorney?
It's Mr. Silverthorne. He just sent an email, so I wanna,
Great, we'll just tell him January 7th at 10, unless we need to go on the record in this case, we'll move on.
yep,
Is
okay,
that
January
any
7th.
custody?
He is.
Okay, so we'll put that on the court note, and probation will go into the update.
Or I meant January 6th, sorry,
January 6th at
Yeah.
10.
sorry, January 6th.
January 6th at 10, sorry.
That was my fault.
Okay.
Assistant.
Well, I know we always say that, but this time it is.
Yeah.
This is true.
I don't know, I'm just sitting here waiting.
Who next?
Ordinance, and then legal.
Six cases.
Your Honor, we are ready to proceed with Mr. Warnes, if I can approach with you. Right, and
Thank you. This is docket 25-4132 FH, people of the state of Michigan versus Jordan Wormnest. Counsel, your appearance for the record.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Good morning, Assistant Public Defender Sarah Donnelly on behalf of the defendant Jordan Wormnest, who is standing to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
Let's say,
Have you taken any medication yesterday or today?
yes.
Is it anything that would interfere in your ability to understand your attorney or the court?
No, Your Honor.
Is there medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And sir, you've had no time to speak with your attorney?
Yes, Your Honor.
And are you a US citizen?
Yes, Your Honor.
With what you're pleading to, which I'll hear in a moment, were you on probation or parole at that time?
Yes, Your Honor.
So would this result in was it probation or parole?
Probation.
So will it result in a probation violation or has that occurred?
It already occurred.
All right, and were you on bond conditions?
No.
Okay. You would agree with that, counsel?
Yes.
All right, thank you very much. On behalf of the people, what is the plea agreement?
Thank you, Your Honor. The agreement in this file is for the defendant to enter a guilty plea to an added count 2 of resisting and obstructing a police officer. Upon successful plea and sentence, the people will move to dismiss count 1. Further, Your Honor, there is a sentencing agreement that any sentence the defendant shall serve would be served concurrently with his current MDOC sentence. And for the court's notice, we will be filing an amended information with that new count.
Thank you. Full, fair, accurate, and complete.
Your Honor, I believe also the agreement dismisses the habitual offender notice. But otherwise, yes.
Okay, I do see it on the sentence agreement sheet that was all signed.
Yes.
Sir, is that full, fair, accurate, and complete?
Yes, Your Honor.
Counsel, you're waiving reading the habitual offender fourth offense notice in its entirety along with count 1
Yes.
as to count 2.
Thank you, Your Honor. People of the state of Michigan versus Jordan Nicholas Wormnest, case number 25-4132 FH. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before this court and informs this court that on or about July 2nd of 2025 at 3615 Dunkel Road in the city of Lansing, Ingham County, the defendant did in the added count 2 police officer assaulting, resisting, or obstructing, did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Ilya Barbanov, ILYA-BARABANOV, a police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his duties contrary to MCL 750.81D1, this being a felony punishable by up to 2 years and or $2,000 in fines. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if not taken at arrest, this being done against the peace and dignity of the state of Michigan.
And I'm sorry, did you say what was punished, what the punishment was?
Yes, Your Honor, 2 years and or $2,000 in fines.
Sir, did you understand what was just read?
Yes, Your Honor.
So you understand police officer assaulting, resisting, obstructing is a felony punishable by 2 years and or $5,000. You would have to pay for any restitution for any personal or property damage, if any.
Yes, Your
If
Honor.
you disagree with the amount, restitution hearing would be held, and I would make the determination based on the evidence that amount can go down. Do you understand all of that?
Yes, Your Honor.
It looks like you signed the advice and rights form. Did you read it before you signed it?
Yes, Your Honor.
And did you understand what you read?
Yes, Your Honor.
If you had any questions,
No, Your Honor.
was your attorney able to answer any questions if you had them?
Yes, Your Honor.
All right, thank you. And do you understand that also you are, by pleading, giving up your automatic right of appeal if you had a bench trial and jury trial? Then whatever you were unhappy about, the Court of Appeals has to take a look at it. Now, if you choose to appeal, you have to ask permission, and they will only hear your complaints if they think your issues are important. Do you understand how that works?
Yes, Your Honor.
And counsel, is there any restitution that you're aware of?
No.
No, Your Honor.
All right, thank you. Sir, as to count two, police officer assaulting, resisting, obstructing, how do you plead?
Plead guilty, Your Honor.
And you understand that, if you violate the law or bond conditions, I do not have to follow this agreement?
Yes, Your Honor.
And if I don't follow it and everything's gone well, then, I would like to withdraw your plea in this manner, but again, go to the pretrial stage, understand that?
Yes, Your
All
Honor.
right, we have good microphones, you don't have to keep
Oh,
moving forward, you need that, negate. All right, and sir, has anyone told you what I will do at sentencing other than the plea agreement?
No, Your Honor.
Because I'll make up my mind at the time of sentencing when I'm fully informed, which I'm not now, do you understand that?
Yes, Your Honor.
All right, and sir, you pled guilty, did anyone force, threaten, or coerce your plea?
No, Your Honor.
Anyone promise you anything other than the plea agreement caused your plea?
No, Your Honor.
You understand that if someone did any of those things, you have to tell me now. Because if you come back later and say that you want to withdraw your plea, I don't have to accept that.
Yes, Your Honor.
And you chose to plead of your own free will
Yes, Your Honor.
after you spoke with your attorney,
Yes, Your Honor.
and you've been satisfied with the representation of your attorney?
Yes, Your Honor.
Sir, did this offense occur on or about July 2nd, 2025?
Yes, Your Honor.
The city of Lansing County of Bingham, state of Michigan,
Yes, Your Honor.
at a specific location known as 3615 Dunkel Road, you came in contact with law enforcement?
Yes, Your Honor.
And was that, excuse me, Ilya, it looks like it's ILYABARABANOV. Barbanov, was that not a police officer, even though you might not have known the name?
Yes, Your Honor.
And were you given some instructions that you didn't follow?
Yes, Your Honor.
What happened?
He basically walked up to me and told me to he went to go act like he wanted to tame me, and I just ran on him and then turned back around and went to go run up the stairs, and he threw me down the stairs.
Okay, was the officer in uniform
Yes, Your Honor.
and gave you an instruction to stop,
Yes, Your Honor.
and instead you ran?
Yes.
So you interfered with his orders,
Yes, Your Honor.
and that could have placed you and the officer in danger?
Yes, Your Honor.
And you understand being in uniform and being told to stop was lawful and you should have complied?
Yes, Your Honor.
On behalf of the people, any additional questions?
No, Your Honor.
No, Your Honor.
Thank you. Our counsel or promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No.
As corporal, like the corporal.
Yes, Your Honor.
Yes.
Thank you. I find that this plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter. Count 1 and habitual for it in its entirety are hereby dismissed, along with any outstanding warrants on this file, if any. Do we have a sentencing date?
January 21st at 11 a.m.
Now, is he in, so are you in MDOC?
He is not. He is currently in Oakland County custody. He has a sentencing date there on the 28th. So my intention is he'll still be in Oakland County custody. He thought he might be in MDOC. He would have preferred to be written by video. I don't know if we can write him by video from Oakland, but yeah, Oakland will be where he needs to be written.
Okay, so you'll be written or you won't yet be in MDOC?
No, they do Zoom there though too, so
Okay.
it's up to you. Really.
We can try.
Either we can do Zoom,
It'd be easier, really.
I don't mind doing Zoom, so we'll either do it by Zoom or in person. Sometimes Zoom, like a couple weeks ago, wasn't working with no volume. And some courts don't do it, and I do it, so we'll figure it out between us.
Okay.
Zoom certainly would be easier if you're waiting your appearance right next to your attorney. But if you do want to talk to her, we can put you in a Zoom breakout room, it's
Yeah.
confidential, so you're okay with that?
Yes, I am.
All right. So you're going to have to cooperate with probation for a pre-sentence investigation report, which we'll talk about at sentencing. Do you understand that?
Yes, Your Honor.
All right, is there anything else I need to order?
No, just to be clear, it's gonna be the Oakland County Jail.
Yes.
Okay, I'll get over it.
Okay. And counsel, you'll let them know that Zoom's okay, otherwise they have to transport.
Okay, honey.
All right, thank you.
Thank you, Your Honor.
That's all for this record.
Do it ahead of time. I don't need my card, but you don't. Actually, I don't need one.
You know.
The next matter is ready.
The Lino matter, Your Honor, Mario Lino, set for sentencing today after a trial of months ago.
This is docket 24380 FC, people of the state of Michigan versus Alcario Leon Lino. Counsel, your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Mr. Lino. He is present with me. Counsel today.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Put your hand down. Have you had enough time to speak with your attorney?
Yes.
Have you reviewed the pre-sentence investigation report?
Yes.
Have you taken any medication yesterday or today?
Just the medication that I was prescribed.
That's fine. Is it anything that would interfere in your ability to understand the court or your attorney?
No.
Is there any medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
On behalf of the people, any corrections, additions, deletions?
Yes, on the cover page, it says status at time of the offense, none. He was on probation, felony bond, and a bench warrant out for his arrest.
And he's on probation, and I'm sorry, what else?
Probation, felony bond, and there was a failure to appear bench warrant for his arrest.
Any objection on behalf of the defendant?
I don't have any information as it relates to the bench warrant, but I believe the rest of that is correct as far as I'm aware.
All right, thank you. Changes have been made. Counsel, additional changes?
Not to the body of the report, Your Honor.
Any changes to the body?
None to the factual content or to the body of the report, Your Honor. Thank you.
And sir, just as a reminder to you, We had a jury trial and you were found guilty of count 1, unlawful imprisonment punishable by 15 years. Count 2, assault with intent to do great bodily harm less than murder or by strangulation punishable by 10 years. Count 3, assault with intent to do great bodily harm less than murder or by strangulation punishable by 10 years. Count 4, interfering with electronic communications punishable by 2 years. Domestic violence, count 5, 93-day misdemeanor. Count 6, domestic violence, 93-day misdemeanor. Count 7, criminal sexual conduct, first degree, punishable by up to life. Count 8, criminal sexual conduct, first degree, punishable by life. Count 9, criminal sexual conduct, second degree, multiple variables, punishable by 15 years. Count 10, unlawful imprisonment, punishable by 15 years. Do you recall that? All right, now let's then go to the guidelines. I'm sorry.
Before we get to the guidelines, there's one other correction thing to
Yes.
make. In the criminal history on page 16, it's gonna be, incident 15 of 17.
Incident 15 of 17 on page 16.
Yes, Your Honor.
Yes.
And then down in the narrative, this is the case that he was on bench warrant status for at the time of this offense. It says towards the end, defendant was arrested on 4/12/2023. That should be 2024.
Change has been made. I think there's no objection.
No, Your Honor.
All right. As the guidelines.
Yes, Your Honor, we're gonna have to take these one at a time.
All right.
So starting with the unlawful imprisonment count,
Yes.
the people need to change the PRVs. PRV 2 should be 30, and PRV 5 should be 15. Now, I know the defense is going to contest this. The reason for this is because of the litany of attempted assault, resisting, obstructing of officers that he has been convicted of. Those are not actually misdemeanors under the sentencing law. Per the sentencing guideline manual, because it's an attempt of a G-class felony, it is scored as an H-class felony.
Okay, so tell me again,
PRV 2,
the 2 is 30.
yes, and PRV 5 is 15, as they were erroneously scored as misdemeanors for PRV 5.
Objection?
Yes, Your Honor, I am objecting. I think it's properly scored as it is. For prior record variable 2, which is prior low severity felony convictions, I think they're adequately scored the way they are, because I don't think that there is a distinction, because those are obviously misdemeanors, those attempt R and O convictions. So they don't comport, I don't believe, with the strict language of the statute as it relates for the scoring of that particular PRV. I think what the statute is talking about, if there was a crime with an E, F, or G, or H, or, I'm sorry, if there was a crime and then there is an attempt of that crime and it gets bumped down in classification, I think what that's referring to is a felony count. An attempt of that felony results in a conviction, but I still think it has to be a felony count for it to be scored as a low severity felony. And I cannot find any specific case where it's stated, for example, attempt R and O, or attempt interfering with electronic communication device, any attempt of a 2-year crime, that it should be scored as a low severity felony. Because my reading of it, it is a misdemeanor, and I think it would have to be a low severity felony for it to be scored under that PR.
If we'd all like to turn to page 10 of the sentencing guideline manual. Attempted offenses in classes E, F, or G. The attempt is a class H offense. Further, on page 9, it talks about how class G offenses are imprisonment for up to 2 years, which makes sense, but any attempt of that would then, by that nature, not be more than a year. What's classified as a misdemeanor for generalities under the law is not the same as classified as a misdemeanor under the sentencing guidelines. That's why the manual's there. That's why it's in painstaking detail like that. So Mr. Austin's reading is incorrect here. The plain reading of this is that attempted offenses in class E, F, or G, which includes the assault, resist, obstructive officers, is a class H offense. And per page 4 of the sentencing guideline book, those are to be scored under the PRVs as low severity felonies. So there are 4 of them in its history. So PRV 2 is required to be scored at 30.
Court agrees, PRV 2 is 30, PRV 5 is 15.
That is the only changes I have to PRVs. That would raise up to 77 and level F.
And what?
F, level F.
And so that would be, what's the range?
Well, we have to go to the offense variables.
Oh, I see, all right.
Now, part of this interplay is the fact that these crimes are a mix of 2 different days. So for this count, unlawful imprisonment, OB 1 and 2 should both be 0. The weapon that they're talking about is the cell phone that he used to hit her in the face, but that didn't happen until the 31st. So it only applies to the charges on the 31st, not the other charges from the 29th. So OB 1 and 2 should both be 0 points.
Council agrees?
I do.
Thank you.
OB 10 should be scored at 15 due to predatory conduct, more than just the exploitation of a domestic relationship. For this, people would rely on the testimony and exhibits and the defendant's own testimony that he had been, before these offenses, messaging her saying he was going to release her naked photos if she didn't do what he wanted. And then also saying he was going to break her door down and beat her ass if she didn't let him in. Both of those are predatory pre-offense conduct designed for victimization.
Council?
Yeah, I'm objecting to that. I think if there is to be a proper scoring to that, it would be properly scored where it is at an intent. I don't think the evidence or the facts as they bore out at trial, either from the testimony of Ms. Ettinger or from the testimony of Mr. Lino, would justify increasing the scoring on that from 10 to 15. And in the statute and the variables goes through the various factors. Just simply because one of those factors exists in and of itself isn't sufficient for the scoring, but I do believe that there is to be a scoring on that. It's properly scored where it's at 10. I would object to it being increased to 15.
Response?
To quote the offense variable 10 from the sentencing guidelines manual, predatory conduct is pre-offense conduct directed at a victim for the primary purpose of victimization. He literally testified that he did these things to make her do what he wanted, because to make her afraid he was going to release these photos, make her afraid that he was going to come break her door down and beat her.
I recall the testimony, OB 10 is 15.
That is all that the people have for offense variables on this one. I believe the defense has some.
Council?
Sure, thank you. First one I'm going to be addressing is offense variable 7. And that I believe is scored on nearly every offense, I think except one. I think interfering with the electronic communications, I think it's probably the only one that it's not scored at. On the remainder of the felony counts, offense variable 7, which is for aggravated physical abuse, they have scored at 50 points. Offense variable 7 is a variable that it's either all or nothing. There's 50 points or it's nothing. And so I think that is significant for the court to consider. For it to be scored for that, the victim was treated with sadism, torture, excessive brutality, or similarly egregious conduct designed to substantially increase the fear and anxiety a victim suffered during the offense. Again, I don't believe that the facts and the evidence as it bore out at trial would justify the scoring of 50 points for that particular variable. Now, just due to the nature of these offenses, obviously, there is going to be a certain amount of, I think, some of those factors being present, just by the nature of the offense alone. But what this particular variable is talking about is something that is so egregious, that goes so far and above, that would have justified scoring 50 points, which is one of the highest points that can be scored for almost any variables under the sentencing guidelines. So, given that, Your Honor, I don't think the facts would sufficiently support the scoring for that. I think it would be properly scored at 0.
Response.
This was egregious conduct designed to substantially increase the fear and anxiety that she suffered. It is not a requirement that it be more than those charges, in the same way that you still charge or score OV1 for weapons in a weapon case. This is egregious conduct. That's why they're life offenses, because the legislature decided this is very egregious conduct. The PSI writer in here details why they scored OV7 50 points. Says, due to the degree the defendant went to instill fear into the victim by choking her, holding her in a headlock for multiple minutes, hitting her on the face with her cell phone, forcing sexual intercourse upon her, and not allowing her to leave. And that's just from what they had from the police report. The testimony absolutely established egregious conduct, and the evidence of the messages he was sending her to control her, the calls that we played, where he was saying, I'm going to beat your ass, I'm going to break your door down, you can't get away from me. It's 50 points, Judge.
Anything further on behalf of the defendant?
No, Your Honor, I stand on my original objection. Thank you.
It's 50 points. I think I agree with the people's assessment. It was conduct designed to substantially increase the fear and anxiety of a victim suffered during the offense. Any other changes or requests to change?
Couple, if I may, Your Honor.
Me. We're still on this count.
To be fair, I think they're going to transfer over to a lot of the other counts. There aren't many individual ones.
Okay.
There aren't many what?
Individual ones.
Yes, Your Honor. The next one I'm going to be addressing is offense variable 19. And I believe that's scored on most, if not all.
I think it's all.
Yes, Your Honor. Offense variable 19, which I believe is scored on all of them, it is scored at 15 points. And I don't think the PSI was clear enough as to exactly what they were specifically relying to. I think there's a lot of inferences that could be made, either relating to the charge. I don't know if it had to do with some of the jail calls or calls over the proposed defense evidence. But in any event, Your Honor, they have it scored at 15 points, which states that the offender used force or threat or force against another person or property of another person to interfere with, attempt to interfere with, or that results in the interference with the administration of justice or rendering emergency services. And again, Your Honor, I don't think the facts or the evidence or the testimony that bore out at trial would justify the scoring of that at 15 points. I think if there is to be a scoring of any kind on that particular variable, it would be more adequately scored at 10, but certainly should not be at 15.
Response.
The reason the PSI writer gave here on page 2 is OV19 was scored at 15 points, as noted in the police report. The
Yes, what
defendant,
the police report?
as noted in the police report. OV19 was scored at 15 points. As noted in the police report, the defendant took the victim's phone out of her hand and any other communication device on different occasions, and he also threatened to break her phone upon movement. And Your Honor, that is an accurate scoring at 15 points because she had her phone in her hand trying to call. He took the phone out. She then went up to the iPad, trying to call, took the iPad away. That's the first day. And then the second day, he again takes the phone out of her hand, won't give it to her, and ends up throwing it across the room. That is physical force that's used against another person or the property of another person to interfere with or attempt to, to interfere with or just attempt to interfere with the administration of justice or rendering emergency services. So I believe that qualifies. It meets the plain written language of OB 19.
Anything further on behalf of the defendant?
No, Your Honor, thank you.
OB 19 is 15, next.
1 second, if I may, Your Honor.
Me.
I think the last one I'm going to be challenging, but I'm not going to be overly long on this, Your Honor, but I think it's offense variable 8, which is scored at 15 for victim aspiratation or captivity. And that is scored for, I know, the CSC offenses, I believe the GBH strangulation offenses. It's not scored for the interfering with electronic communications. It is scored for the unlawful imprisonment as well. Again, Your Honor, this is a situation where to justify that scoring is that the victim would have to be aspartated or taken to another place of greater danger or to a situation of greater danger or was held captive beyond the time necessary to commit the offense. Again, I think the facts and testimony bore out these offenses were committed. That is what the jury found after listening to the testimony of Ms. Ettinger and Mr. Lino. But I don't believe the facts support the scoring of that because that again, that would require beyond the time necessary to commit the offenses that he was found guilty of. So I think that would be properly scored at 0. I'm objecting to the scoring of 15.
Response.
Just to be clear, are you objecting to it for the unlawful imprisonment counts or every count? Just one on instruction.
Every count.
Okay. He was literally convicted of unlawful imprisonment for each incident. I don't know what else could possibly be said for OV8. If I need to say more, I'm happy to, but the jury found him guilty of unlawful imprisonment, holding her captive.
I think the issue is, and if you could address the asportation to another place of greater danger.
OV8 is one or it's both, like it's both options. I don't have to prove asportation if captivity is there. It's, was she taking a place of great danger or was she held captive?
Response.
Your Honor, it's beyond the time necessary to commit the offense that was committed, simply because he was found guilty of unlawful imprisonment. Otherwise, then it would just be automatically scored in every case where there was a finding of guilt on that, and I don't think that's what it says.
It's absolutely scored in the cases where they're convicted of unlawful imprisonment, not just for the other charges, but for unlawful imprisonment, specifically because the jury instructions for unlawful imprisonment say holding them for even a moment is enough for guilt on that. That is the time necessary to commit that crime of unlawful imprisonment, a moment. And the testimony was clear, it happened for far more than a moment, where she was not allowed to leave, where he was keeping her on the bed in his place and wouldn't let her leave, made her go take a shower, wouldn't let her leave. And on the second day, has her in a headlock on the bed while scrolling through her phone and won't let her leave.
OV8 will remain as is 15. Next.
No further challenges to the guidelines, Your Honor. Thank you.
All right, so on the unlawful imprisonment, I have 77 on the PRVs. What's the total OVs?
185. Goes down by 11, but up by 5.
So what are the guidelines?
Guidelines become 62 to 114.
Changes have been made and the account one, unlawful imprisonment. Are we gonna go then to the next one? So there's changes on all of them, basically.
Yes, Your Honor. The changes are going to be very similar on the charges from that same incident date. So for count 2, assault with intent to great bodily harm was the murder by strangulation. It's all the same requested changes from the people, both in the PRVs and the offense variables.
Same objection, same ruling. Unless you'd like to add.
No, Your Honor,
All right.
maintain my prior objections.
Absolutely.
PRV 2 is 30,
Yes.
PRV 5 is 15,
Yes.
total is
77.
level.
F.
Going to the OBs, 1 and 2 are 0,
Correct.
and 10 is 15.
Yes.
Total
185.
level,
Remains the same as max.
range,
43 to 76.
making the changes on the basic information sheet. Count 3,
Now, this is one of the different ones. So first, the offense date needs to be changed to March 31st, 2024.
changes been made,
Now, on the prior record score, that's the same requested changes. 2 should be 30 and 5 should be 15.
changes have been made with the total,
77.
level,
F.
and the OBs.
So the offense variables, the only requested changes here are the same one for OB 10 for it to be scored at 15. And then OB 11 should be scored at 0. This incident date didn't have any sexual penetrations, and so OB 11 should be 0 for this one.
What about 1 and 2?
1 and 2 are appropriately scored as 10 and 1 respectively, as this was the incident with the phone into the face.
Total,
That would make the total to 146. I don't know if defense has any other challenges for this one because it is a different date, so.
Maintain all my prior objections that I've already placed on the record, Your Honor. Obviously, I would not be objecting to OB 11 being scored from 50 to 0, is that correct?
same rulings, and so, the total's 146, what's the level?
Level remains at a 6, and the range becomes 43 to 76.
Changes have been made in the PSI, on the basic information sheet, now going on to offense 4.
For offense 4, it's the same PRV challenges as before, for 2 and 5.
Same rulings, objections preserved, so it's 30 and 15.
Yep, and the total is 77 for the level of F.
Okay, OBs,
For the offense variables, the only change here would be to count 1, as that should be 0.
okay, so the 156,
It should be 65.
on the, wait a minute, are we on the POV? We're on the OBs, right?
Yeah.
They have a total OB of 166, and we're just subtracted 10.
I don't have 166 for count 4, I have 75. Did you potentially go 2 pages to?
Oh, maybe, it's possible, let me just see. Yeah, I got two pages stuck together, yep, stuck together, okay. So we're on interfering with electronic communications, correct?
Yes, Your Honor.
So let me correct it. 2 is 30. 5 is 15, and then that's a total of 77 F grade. And you just have the one change, which would be
OB1 being scored at 0.
okay, I'm sorry, so now it is 65
Correct.
level
Still 3,
and range.
5 to 17.
All right, let me make that change on basic information sheet. Changes have been made.
Now on to the criminal sexual conduct first degree. It's marked as count 7 of 10. It's all of the original changes again, so PRV 2 and 5.
2 and 5 are 30 and 15.
Yep, for a total of 77, level F.
Changes have been made.
And then the offense variables, it's the same requested changes as before to OBs 1, 2, and 10.
So it'd be 0, 0, and 15. And the total
160.
level,
Remains at 6.
range,
270 to 450 / life.
all right, let me go to that. All right. Changes have been made in the basic information sheet. Next,
Count 8 of 10 criminal sexual conduct first degree, the exact same changes as the last one.
so we have 30 and 15.
Yep.
Total is 77 level up.
Correct.
And then we have 0, 0, and 15, correct?
Yes.
Total would be 160,
Correct, Your Honor.
and same range, 270 to 450 / life.
Correct.
We're going to change the basic information sheet. Changes have been made. And just again, all the objections are preserved. Going on to CSC second degree.
The same PRV changes again.
So 30 and 15, still total 77 and F, correct?
Correct. And then the same offense variable changes.
All right, 0, 0, and 15,
This brings the total to 185.
level,
Remains at 6.
range,
62 to 114.
changes have been made in the basic information sheet. Now we go to 10 of 10.
Yes, Your Honor, this is the other odd one out of the group. So we need to change the offense date to March 31st, 2024.
Change has been made.
And then same prior record variable changes for 2 and 5.
30 and 15, changes have been made.
Total is 7, level left.
I'm sorry, total is
77.
77, okay, level up.
Yep.
Uh-huh.
Then for the offense variable, the only changes here is that OV 10 should be 15 and OV 11 should be 0.
So
Total comes to 146, remains at level 6.
range,
62 to 114.
all right, this information sheet is consistent with the scoring sheets. Do we need to change the inner pages in regard to what they noted under the recommendation narrative?
I don't think so. Oh, I see. Yeah, we probably should.
No, I'm sorry.
Oh, yeah, they do have the, right at the top of the recommendation. You're correct.
I'm changing count 1 to the 62.
Mhm.
Count 2 will be 43.
Yep. We're talking that big first paragraph, right?
Yes.
Gotcha.
Yeah. And then count 4 would be 5 to 17.
Yes.
Count 7, 8 would be the 270 to 450/light. And then I think was good.
I believe so, Your Honor.
Okay. Any other corrections, additions, deletions from either one? If not, do we have anyone who wishes to address the court?
Your Honor, we do have a victim impact statement, and we have one of our victim advocates to read it.
Good morning, please raise your right hand. Do you swear or affirm that the testimony you're about to read will be read accurately as written on the page before you?
I do.
You may put your hand down, please state and spell your name for the record.
My name is Isabella Jones, ISABELLA JONES.
Thank you. You may read.
Victims of just one strangulation are 100% more likely to become a victim of attempted homicide by the same partner in the future, and 800% more likely to become a victim of homicide by that same partner in the future. A lot of people hate their abuser, but I don't. I actually thank Alcario, because if it wasn't for him and his unhealthiness, I wouldn't be where I am today. I am improving my relationship with God, receiving so many blessings, and really taking this time to heal myself. Still, I cannot find my happiness and innocence again. I am forever changed. I will never be the same again. No amount of time will justify his actions, but keeping him in prison is a safety measure to keep me and other women he has already had previous domestic encounters with, and ones that have no idea the horrible man he is, protected from him. I was strangled in a headlock for minutes and could not breathe for what felt like so long. I sat there, and in my head, there was no escape. So after trying, I gave up as the drool started coming out of my mouth and my arms went limp. Finally, he let go, just to try to continue to hit me with my phone. There I am, feeling degraded, powerless, worthless, so sad, weak, and stupid, crying as if it was my fault he made those actions. My airways were completely cut off. My eyes felt like they were going to pop out of my head. Mind you, this is after the encounter of him refusing and blocking any way of me leaving. I was dragged and pinned down, getting strangled while he was on top of me, telling me I wasn't leaving him, keeping all of my electronic devices hostage. He did not give my phone back until after he forced me to have sexual intercourse with him while on my menstrual cycle. Thank God my mom arrived to help me get out, because who knows what would have happened next. Then he makes the irrational decision to come to my house at 5:45 a.m. that next morning, after not sleeping all night, continuously harassing me, demanding me to let him in just to hurt me more, just so he has all the power, just so he can satisfy his anger, just so he can make me scared of him. But he failed to realize I am strong, courageous, outspoken, and very determined. It hurts my heart so bad to be in this predicament with Alcario, and it doesn't make any sense, because his heart was not hurting when he chose to do all these horrible things to me. That just shows how big my heart is, though. Every day I battle if this is what's supposed to be happening. But then I realize it's out of my control. It was all in his control. I'm not the one attacking him back. He needs the lesson. He needs to sit and really think about turning his life around. The last thing I want to do is to take him from his children, but I feel as if they are unsafe if he does not self-reflect. If he ever gets out of prison without the correct amount of time served, I know he will come after me and possibly others, the same thing he did to his ex-girlfriend. I will never get to live a peaceful life again with him in or out of prison, but I will feel more safe than him being out and trying to find me and hurt me worse than he already has. I fear I will never feel safe with a man again. I cannot even think about any type of relationship without shaking and crying. I can't watch my favorite TV show, Law and Order SVU, without having a panic attack. I just want him to realize this is not okay, and there's consequences for your actions. Nothing will ever justify, because I will forever be a changed person and traumatized. Now I will never forget him or the horrible things he did to me, but as God did and wants everyone to do, I forgive him. My dad never even disciplined me using his hands or objects. I struggled to swallow for 2 weeks, and my throat felt sore for almost 2 months after it happened. I didn't do anything with my family and friends for at least a month, besides April 3rd, my birthday, and I stayed inside with just 2 people because I was too afraid to go out. I have nightmares, but my mind blocks out Alcario, so it puts someone else in the place doing what he did to me. I try to distract myself to just move on, but when I'm not distracted, it's all I can think about. And I just cry and wonder why. All I want to do is move on. It's been over a year, and I still cry at least once every single day. I isolate myself. I'm not open to new relationships. I'm scared to go outside and enjoy myself. My brothers can't play fight with me the way we always have growing up. I can't live in the home I was living in, causing me to be homeless, live in shelters, and eventually moving to Arizona. And I still watch my back, because now I just live out of fear. His family follows me and records me. Now they have seen me in my car and recorded that as well. They send little things and threats just to pop up on my social media, then they delete them. I broke relationships with family and friends. He made me feel less than I am. Then he proceeded to tell me he loved me. That's what you do in a relationship. He wanted me to have his kids, and that's what makes him love me more, to see how much I deal with, and so on. There's multiple other women he's done this to, so I want justice for them as well as myself. He's going to be a monster if he wins this one too, because it's going to make him think he has even more power over people and can do this to anybody without consequences. He had a ton of absurd behaviors throughout our relationship that he manipulated me into believing was normal. He's also had previous accusations of domestic violence that I never knew about. Life goes on, and nothing will ever fix or take back the trauma he put me through sexually, emotionally, and physically. Nobody will ever be able to get close to me the way he did. I will never put aside red flags just because I want and love somebody so bad to let it get to the point it got to. I don't even know how to do a relationship or love somebody the right way, being as I was only 19 years old. I looked at the mental abuse of Alcario as him trying to fix me and make me a better girlfriend. This justice is not only for myself, but the pieces of me that died in the hands of Alcario, and for the other women who were afraid to stand against him and got hurt by the words and hands of this narcissistic sociopath. I had a best friend, Haley, that died from the hands of a grown, abusive man, and I never wanted to end the same way for myself.
Is she here or is she on Zoom?
I believe she is on the Zoom.
All right, so if you're listening, Riley, you are forever changed, but I think you're also changed in a good way because you're stronger and you are the one who is powerful now. He has lost any power that he had. None of this was your fault and you were bravely testified and faced him, which I hope helps in your healing. And the trauma isn't gonna go away, but in time it will get better. So I wish you well, and I guess the question I have, I don't know who can answer this, but maybe the people can, is there restitution being sought?
I don't believe so, Your Honor. We didn't receive anything about restitution.
All right, okay. Thank you for your statement and for coming forward. On behalf of the people, what would you like me to know?
Your Honor, the probation recommended a minimum sentence of 25 years in these matters. With the updated guidelines, his guidelines on the first count of CSC first is between 22 and a half years and 37 and a half years or life as the minimum. That is discretionary consecutive with the other count of CSC first, which has another minimum guideline range of 22 and a half to 37 and a half years or life, which is again, discretionary consecutive with the rest of the case, which has next highest one's guidelines is 62 to 114. The recommendation is almost at the bottom of the guidelines, and I don't think that's appropriate here. The guidelines don't account for a man like this. Just from pure numbers, they don't. Because he has a prior record score of 100, or I'm sorry, an offense variable score of 160, and the guidelines cap out at 100. He's more than 50% greater than the criminality the legislature thought they'd be dealing with when they made these. And that doesn't even take into account the other things that aren't scored by the guidelines. The fact this isn't the first woman that he's put his hands on. As the court knows from the other acts notices that we filed before trial, he put his hands on the mother of his children more than once. And as he admitted to at the trial, while the trial is going on, while he was in the classes that he provides certificates for, he is threatening that woman, saying, on July 18th of 2024, I'll knock your fucking teeth loose, I'll smack you to the floor, do you want your ass beat? He's saying that from jail to a different one while waiting trial for this. Then while the trial is going on,
Sir, I can hold you in contempt and we can continue this in 93 days. You need to be quiet. This is not your time to talk. I will give you time to talk, but it's not now. So speak up again, officer. If he wants to interfere again with what the people are saying, please put him in lockup. We'll continue this in 93 days. Contempt carries with it 93 days and or $7,500. You don't have the $7,500, but you got the 93 days. No more uttering, no more faces. Be still, sir, and quiet. You may proceed. I'm sorry for the interruption.
It's okay. Then while the case is going on, he keeps trying to introduce evidence that he knows has been deliberately cut to benefit him and to keep out incriminating parts with his sister. Because as he said, I just need to make sure that nowhere am I strangling her there. And he's still talking about that with her while the case is going on, while the trial is happening. And while the trial is happening, he's violating the sequestration order by talking with his proposed witnesses about the testimony that's happened. We had to address that as well. On top of all this, he was on felony bond with this court for gun and drug dealing charges, where in that case, at his feet, they found a bag that contained, let's see here, a black 9mm handgun with a round in the chamber, 33 rounds of 9mm live ammunition, 3 grams of cocaine in a plastic bag, marijuana, codeine and acetaminophen pills, as well as scales.
Scales.
Yeah. So that's what he's on bond for, while also on probation. While also having a bench warrant out for failing to appear when he commits these crimes. And going back to his criminal history, that is not a one-off. Well, these are his first felony convictions. He has been charged with felonies 7 previous times. They were either dismissed or pled down to misdemeanors. And I went through, in just the criminal history of the PSI, he's failed to appear for court 9 different times. He's committed new crimes while on bond 8 different times, and included crimes while on probation 3 different times. Even when he's given breaks, he does not stop. Instead, at 30 years old, he goes and finds a 19-year-old girl to manipulate, assault, and rape. This is not a bottom of the guidelines case, and this is not a bottom of the guidelines defense. There are discretionary consecutives here. I am asking this court to sentence him consecutively. His guidelines for each of the CSC first charges are between 22.5 years to 37.5 years of life. This court could sentence him to life. I'm asking this court to sentence him to 50 years as the minimum. I'm asking this court to sentence him to 25 years for each of the CSC first cases, be consecutive with each other. Barring that, Your Honor, if the court does not feel that it is comfortable doing a consecutive sentence, this needs to be a top of the guideline scoring. Because this is it's not even a top of the guideline defendant. It is past the guidelines. It is more than 50% past what the legislature made guidelines to cover. He irreparably damaged this girl. He took every step he could to try and manipulate the case. The jury found him guilty of these. He needs this type of sentence. The community needs this type of sentence. And both Riley and his previous victims need this type of sentence. Thank you.
Counsel, you and your client may approach. You may proceed when you're ready.
Your Honor, before I begin with allocution, there's just a couple brief matters that I wanted to address. I wanted to make one objection to what I anticipate will be a part of the court's sentencing. I know this is a case where Mr. Lino has an automatic right to appeal, and this is just very briefly as it's going to relate to the lifetime sex offender registry requirements and everything that goes along with that. I know the status of the case law, and I know the court is obligated to follow it. However, constitutional challenges can be raised at any stage, and I'm just going to preserve that issue for appeal. The issue of lifetime sex offender registration and all that it entails, I'm just going to make constitutional challenge to that, particularly under the 8th Amendment, particularly given that the lifetime registration occurs just simply by virtue of the conviction of the charge. There is no assessment or requirements that assessments be done on a periodic basis to see if treatment or supervision needs to be either upgraded or downgraded, as other states have done. So I just want to preserve that issue for review.
Thank you. You've preserved it. Anything else from you, Tim?
Just before I begin, I did want to present the court with numerous certificates that Mr. Lino has been awarded while he has been incarcerated at the jail, if I may.
You may. Thank you. Court has been handed the certificate of achievement from the CATS Substance Use Group, the CATS DBT Skills Group, successful completion of the financial wellness course, seeking safety program, and 15 weeks of restorative practices focused on restorative justice philosophies, circle processes, and skill development and conflict resolution. And additionally, the CATS coping skills group. And looks like he's been also participating in GED classes. Is that what this is?
I believe that last one, I think, has to do with Lansing Community College. I think the Battery Boot Camp.
I see, okay. Looks like he's completed a number of different classes, and they do look, it does say post-secondary. Thank you. You may proceed. Would you like this back?
Thank you, Your Honor. Your Honor, on behalf of Mr. Lino, certainly the court heard the testimony, the jury heard the testimony of Ms. Ettinger, Mr. Lino, and they made the findings that they did. What I can say on behalf of Mr. Lino is this is his first felony convictions of any kind, as the court is already aware. Mr. Lino has never been not only convicted of a felony, certainly never been convicted of anything of this serious nature, of this magnitude before. But some positive things I think to point out for Mr. Lino, even in the pre-sentence report, it states that he believes that he could benefit from addressing substance abuse issues through substance abuse treatment. So he has that realization that he has things that he needs to work on. I don't think it's in dispute. Mr. Lino has never claimed to be a perfect person. He never claimed that on the witness stand. He admitted to certain things. At a minimum, he admitted to domestic assaults against Ms. Ettinger. So this isn't a situation where he's completely trying to obfuscate responsibility for any and all actions. He owns up to what he believes that he did, but he wasn't going to take account for what he believed that he did not do. That is his right, and I would certainly ask the court not hold that against him. The jury did make the findings that they did. But as it relates to the factors that the court must look at when determining what a proper sentence is, even if the court were to sentence Mr. Lino at the bottom end of the guidelines, we are talking about decades of incarceration. That is going to be an extremely significant amount of time that Mr. Lino is going to be removed from society and his family. So that is certainly, I think, a very adequate punishment. And again, decades away from society, I think would be an adequate deterrent to deter others who may wish to engage in the same or similar conduct. And I think given what Mr. Lino has been working on, as the court can see, while he's been incarcerated by engaging in various classes and various programming. And again, he admits and acknowledges that there's things that he's done wrong and that there's things that he needs to work on. I think that addresses the rehabilitative aspect of Mr. Lino. And given all of that, and given his lack of prior felony criminal history, I think would demonstrate that as well. I don't believe that this is a sentence that would call for
consecutive sentencing. Oh, again, Your Honor, even if the court were to sentence Mr. Lino at the bottom end of the guidelines, that's putting him as a middle-aged man before he even comes before the parole board. And the sex offender registry requirements, those are lifetime. And everything that goes along with that, that is going to far surpass any term of incarceration that the court can impose or any supervision under parole. And that's going to be a measure of protection for society and a level of supervision and a level of significant restrictions on Mr. Lino's liberty that he's going to have for the rest of his life because of these convictions. So given that, Your Honor, I am asking the court to sentence Mr. Lino concurrently on these counts. And I'm asking that the court fashion a sentence that would be at the low end of the guidelines. Thank you.
Sir, what would you like me to know? Nothing?
No.
It's troubling that you don't even want to say, I'm sorry to the victim. Very troubling. This was a horrifying case. Cannot imagine the trauma that she endured during these offenses, and it will take a lifetime of healing. You, from the testimony I heard, seemed to take great pleasure in taking power over her as you were causing her pain. The amount of rehabilitation that is needed is significant. I am impressed that you have kept busy while in jail. I don't know that you learned anything since you couldn't even say, I'm sorry, since you couldn't be accountable before this court, before the victim, before the community who heard this case. I find that problematic. You are remanded to the Michigan Department of Corrections as to count 1, count 9, and count 10. You will serve 114 months to 180 months with credit for 587 days. As to count 2 and count 3, you will serve 76 months to 120 months with credit for 587 days. As to count 4, you will serve 17 months to 24 months with credit for 587 days. As to counts 5 and 6, the 93-day misdemeanors, you have already served more than the max on that, so you get credit for the 93 days, credit for 587. As to counts 7 and counts 8, you will serve 450 months to 800 months. All of these will be served concurrently. As to the state costs, as to the amount you will pay at $68 times times 8. And then $50 times 2, so it's $100 for the 2 misdemeanors and the rest are felonies. You'll pay $130 crime victims. I'm waiting, fines, costs, and attorney fees, finding that you are indigent. You will have lifetime registry under SORA, comply with SORA. You will receive sex offender treatment while incarcerated in the Michigan Department of Corrections, and you will have no contact whatsoever with the victim or her family. And if you do that either directly or through third parties, I will personally call the warden and make sure that all communication with all devices, telephones and other devices, cease to occur with you, so that your family and friends cannot call you, but rather they'll have to come down and visit you wherever you land. No contact means she and her family do not exist in your world. No direct messages, no Hallmark cards, no carrier pigeon messages, messages by smoke signal. Don't get creative, because I will make that phone call. She doesn't exist in your world. You need to also participate in anger management, cognitive behavioral treatment, and any trade school you wish that's offered. Additionally, if you are fortunate enough to go to a facility that has art therapy, animal therapy, you need to participate. You need to have a healthy mind, but you also need to learn how love is. Animals love unconditionally and they do not harm you. You have 42 days to appeal to request appellate counsel. I do find that this punishment for each of the 10 counts is appropriate, and that your rehabilitation will take literally a lifetime given the severity, the nature, and the deliberateness of your actions. I do hope this is a deterrence to others and that society is protected by placing you in a place where you will be safe, others will be safe, and you will be rehabilitated, hopefully. I also find that it is proportional and reasonable given the nature of each of the offenses, both separately and collectively. Please hand him his appellate rights.
Your Honor, I actually have an appellate rights form that's been filled out and signed by Mr. Lino. Can the court accept that for filing?
We may, if you give it to the clerk, sir, you'll be appointed an appellate attorney. And we'll start working on transcript.
And the only other final matter, Your Honor, I believe Mr. Lino was also here on a status conference on his remaining case.
Yes, Your Honor, on file 23-715FH. While the people could go forward with that, as it is discretionary consecutive with this case, we have a nollie in hand. We believe that.
You may approach. Court will sign it, we'll give you a copy and your client a copy.
Thank you, Your Honor.
Thank you. Is there anything else we need to address?
Not on behalf of the people.
Nothing on behalf of Mr. Lino, Your Honor, thank you. Yes, please.
Brian and Paige want a copy of it now too. Okay. We can make 3. Go for it. Thank you, that is all for this record.
Thank you, Your Honor.
I can't because of safety. I'm not allowed to do that, ma'am. Of course not. Which one?
This SI.
What time is it at?
11:30, I think.
Oh, I see it.
Hold on. Jared, Adam, hang on a second. Let me get you the dolly.
Oh, I'm not going anywhere.
Yeah, no, they need to wait.
Yeah, I lost my timer.
Do we go on the record? Brian? Would you ask me?
Yes. Let it reject.
You don't have an interpreter.
Huh?
You don't have an interpreter.
Then no, we cannot.
Which one?
Yes, good to go, get a new date.
I can reset, okay.
All right, this is docket 13337 FH, people of the state of Michigan versus Jerome Hagler. Counsel, your appearance for the record.
Morning, Your Honor, Natalie Maycomber on behalf of the people.
Good morning, Your Honor. Jade Mathis on behalf of Project Clean Slate, on behalf of Mr. Pegler, who's here on Zoom with, I believe he's turning his camera on.
Yeah, I see him there. Yep. All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. An application is set aside, convictions was filed on August 25th, 2025. Are the people in receipt of the necessary documents from the state police and the attorney general?
That we are, Your Honor.
Any objection?
No, Your Honor.
All right, counsel, what would you like me to know?
Yes, Your Honor, I do want to note that under 780621 MCL, my client there was not any accidents or any injuries that occurred during this incident. He was not driving on a commercial license or chauffeur's driver's license. He did have to complete probation and successfully completed that. He also does not have any active or pending cases. He has been doing well. His post-conviction circumstances have been relatively well.
Just a minute, you got, wait. You just gotta slow down a little bit. The court reporter, there's a little blip, especially on Zoom, in the courtroom too, but especially on Zoom, gotta slow down a little bit because sometimes there's a little delay. So let me see where she ended. She'll tell you where to pick up, okay?
Okay, thank you.
He also does not have any active pending cases.
Yes, and he is currently employed as a barber. He's been a barber for about 7 years. He's indicated that he does have a GED and he's completed some college. He has one son who's 4 years old. And the reason that he's requesting the expungement is because he said for housing opportunities and job opportunities. And then I do want to also point out that he's been crime-free. This looks like his last conviction, Your Honor, and he had a conviction in 2005 as a juvenile.
All right, thank you. Sir, what have you learned from all this?
I learned to not drink and drive and not violate the law. I do thank you for your sentence that you gave me back then. It did teach me a lot.
All right, well, you certainly have accomplished a lot as well. So that's on you. You did great things. So
Thank you.
keep doing the right things and teach your son that you can make mistakes, but you can make amends and get over them and learn your lessons, which certainly you have. The court finds the Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for assault crime set aside under the statute during their lifetime. There are no criminal charges pending against the applicant. The applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant has not previously had a felony conviction for the same offense set aside pursuant to the statute. And the time period required by the statute for both convictions listed in item 1 has passed. An opportunity has been given to the Attorney General, State Police, and prosecuting official to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of the application more than warrant and justify setting aside the convictions, and it is consistent with justice and public welfare. Therefore, it is ordered by this court that the application is granted as to the 2 convictions listed in item 1, and that pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. if the conviction is for an offense that was reportable to the Secretary of State in accordance with the statute, the driving record shall not be expunged. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read, dated, and signed in open court. Sir, if you were here, I'd shake your hand and give you this personally, so I'm doing it virtually, all right? So I have a very good clerk. The clerk is going to enter it today, and we'll make sure you all get copies. However, counsel, I don't run the other departments. I often wish I did. They've been really good since COVID. There was a lot of delay, but now pretty much this paperwork's caught up. So if you find in the next 4 to 6 weeks that it's still open, please let me know so I can make a phone call for you. All right?
Thank you, Your Honor.
Okay.
And congratulations.
All right.
Thank you, Ms. J.
Sir, my last order for you, and this is an order, was to go out with your family and have a nice dinner celebration. Can you do that?
I will.
All right, well, that's an order and a promise. Happy holidays. Thank you.
Thank you.
Thank you, you too.
That's all for this record.
I have one more left. Natalie, do I have one more left?
What is it? Really? I don't know.
Yeah,
Huh?
I think we only have one more left. this
One
morning.
more what?
A sentencing.
Okay. Is anybody here on the sentencing?
Kyle Slater, yes.
Okay, let's do that. All right, this is docket 23619 FH, people of the state of Michigan versus Donald Slater. Counsel, your appearance for the record.
Jacob Froman, on behalf of Donald Slater.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth on the penalty of perjury?
Yes, Your Honor.
You put your hand down. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
None.
Have you had enough time to speak with your attorney?
Yes.
Have you reviewed the pre-sentence investigation report?
Yes.
And you recall that you pled no contest to count 1, weapons, firearms, possession by felon, punishable by 5 years, and count 2, domestic violence, 93-day misdemeanor?
Yes, ma'am.
All right, thank you. And is the victim here? All right, thank you. She has raised her hand. She is here. And on behalf of the people, are there any corrections, additions, deletions?
No, Your Honor.
There is one correction on page 1 of the evaluation and plan. In the 3rd paragraph, it states that the defendant relapsed from opiate use leading up to the instant offense. That would be inaccurate, as he relapsed prior to getting picked up in August of this year.
So what, how would you like to change it? So he reported he relapsed from opiate use leading up to the instant offense, so.
Leading up to the, just in August of 2025 is probably, get rid of leading up to the instant offense.
So, okay, so he reported he relapsed from opiate use in August of 2025. Any objections to that?
No, Your Honor.
And
So, let me just go to the cover page a moment. Sir, you would agree that that's correct?
Yes, ma'am.
Okay. So on the cover page, it says substance abuse history, so it should actually read 2025 under opiates, right?
Correct.
Okay, so I'm gonna make that change as well. And then is that also probably on the inside. Under substance abuse and changing it again, the end date 2025. All right. Anything else?
Jail credit, I know he had the contempt sentence, but he was held pending bond violation hearing, so I was thinking he may get some credit for that unless it just was all attributable to the contempt.
Contempt generally doesn't get credit for, right?
That's correct, Your Honor.
So, okay.
No additional deletions, corrections.
And what about the scoring?
Scoring is accurate.
People agree?
Yes, Your Honor.
All right, thank you. Does the victim wish to address the court?
Yes, Your Honor.
Thank you. Sir, if you could have a seat with your client. Thank you for being here in this talk. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down. Please spell your name for the record.
My name is Jessica Slater, JESSICA, SLATER.
Thank you. What would you like me to know?
So my statement is more in a positive note rather than a negative note.
That's okay. That's good.
I'm nervous, I'm sorry.
Take your time. You're fine. Do you need to sit down? Are you okay?
No, I'm not. So, Mr. Slater and I have been in a relationship for 8 years total, been married coming up on 5 years. We do have 2 sons together. At the time of the incident, the family stress in the home life was very, very stressful, and it was outside of his hands, my hands, just in general.
What was going on? Can you tell me?
I can give you some, yeah, definitely.
What was it, financial, emotional?
I mean, it was both, like, it was financial. It was, we just purchased, we were like a year into purchasing a new home, new renovations, but also I have a son who is now 16 years old, and he started a terrible journey. And when I say terrible, I mean getting into drugs and stuff, running away continuously, lots of trouble at school and stuff. And me, myself personally, I was going through a lot and still continue to this day with that. But
how's your son doing?
He's actually staying with a friend right now. It's a little better, but while he was out of the home, has been out of the home or whatever, and while I was pregnant, I was at home alone trying to deal with my son, and he was incredibly, he's an abusive child, like very, very abusive. I petitioned the court to put him on probation. I've done everything, put him into residential treatment programs. I had even found him overdosed, where I had performed CPR and called 911. He was put in a hospital, and then also had to go to Grand Rapids Hospital too, because they thought he did damage to his heart and stuff. But it's just not, that's still even a never-ending battle.
Okay. Yeah, that's very stressful. Is his father involved?
You know, his father is in prison, actually. He has a long history of drug abuse. He hasn't been in his life since probably 2. Okay, I want to say 2 or 3.
I'm sorry you're going through all that.
Then
this happens, right?
Right. And it's just, it was a lot, and things happen. And Mr. Slater, Don, this whole 2 years has made sure we have been financially stable. We got our house together. I can't afford any of that myself. And he has made sure we didn't lose our house. He has made sure our sons have been well taken care of. He has worked continuously. He has sought counseling and therapy. And I am willing and want to do marriage counseling with him as well, because we need to communicate. We need to, but
So
that
was your
was
intention to stay married to him?
Oh, absolutely. Yeah. That was a one and done situation. There's nothing 5 years prior or these 2 years after. There's no threat. I don't feel no threat at all. And I would love for him to be able to come back home and help me raise his boys and do the homestead. I feel like, I'm so sorry.
I'm trying to find my words. I had so many things I wanted to say and they're all just kind of losing
Do
me.
you have any weapons in the home?
No, after that, I got rid of them. I gave them to my uncle to keep.
So if he were to come home today, do you feel safe?
Absolutely.
And how many children do you have with him?
I have 2 children with
And
him,
how old are they?
1.5 and 6.
And does your 16-year-old get along with him?
16-year-old doesn't get along with anybody.
What would
Which
you
is
do?
why he's at a friend's house right now. He's been there for a couple months now. That was the last incident. He had kicked in like my office door and was threatening to do things, and he had a friend's mom reach out to me and said that he can stay with her.
So is that under a guardianship?
They just reach out to me, like, I still have the insurance on him and everything and keep in contact with him through messaging and stuff and through the parent of the other child too, and make sure that what he's doing is okay. I mean, it's obviously under supervision of another person, but I got him enrolled in school and everything, so we're just trying to get him there, right? Like, when he comes home, there is gonna be issues. If he comes home, if he were to, there would be issues, but that's something that counseling and if we have to deal with courts, like we petition them to be a part of that, to try to do some family. Well, we're willing to do anything and everything for the future to make everything go smoothly as possible.
So what are you asking me? What do you think should happen here? Do you think he needs probation? Do you think he's done enough? Do you need my supervision to watch you? What are you asking me?
I definitely don't need your supervision. As far as being away from the home, I think he's done enough, most definitely. I mean, as far as probation goes, I don't think he needs it, but if you guys do to establish, like, as far as like the counseling and stuff, then that is entirely on you, but I would love for him to be able to come home and help, not just be a financial figure, but also be a father figure and a husband again.
Okay. Thank you. I appreciate you being here.
Thank you.
Good luck with your son.
Yes, thank you.
But ma'am, there's also, I don't know if you know this, but if he does come home and there's a problem, you can reach out, Community Mental Health has somebody on call 24 hours a day. They'll actually come to your house.
Their crisis hotline?
Yes.
Yes, yeah.
Good.
Thank you.
All right. Counsel, what would you like me to know?
Mr. Slater does have somewhat of a bad criminal history, but it all stopped around 2017 when he went through the Swift Insure program in Clinton County. That's when he started his business in construction and started to be a lot more responsible financially. Obviously, this incident wasn't something that was foreseeable from his prior criminal conduct. And his prior criminal conduct was primarily theft related. And the allegations in here are more assaultive related and weapons. But given the unique facts of this case, I think that Your Honor would be in a position to just order fines and costs. And Mr. Slater has taken substantial steps since he got out this time to go through counseling, initially individually, and it's structured to go into joint sessions with Ms. Slater on 11/25 is the next appointment, and thereafter they're going to have the wife join the sessions. Telling from my perspective is he has the 2 children, but he also has the 3 stepchildren that he's been involved in all of their lives. He's helped to ensure that they're provided for. He lives in a very nice house. He's got a very expensive mortgage. He's got a couple trucks that are affiliated with his business that he has to pay on. He's got the fiscal responsibility at this point in time. He's had a tremendous amount of time to comport his actions appropriately. He served his time for the contempt in this. Most telling from my perspective is that back in 2023, when this initially arose, he ended up doing a psychiatric diagnostic evaluation and also followed through with some psychotherapy. during the pendency of his case prior to there being an absconding. He was also compliant with the tether pending the contempt charge. So given the positives in this case and the length of time that's passed since the charges have been initiated in the victim's position on this, I think it's going to be best for their family unit and dynamic for him to be able to be integrated back in whatever form that Your Honor feels to be appropriate. But again, I think that fines and costs would be inappropriate. So,
Sir, what would you like me to know? And tell me about any treatment you've done since this case started.
As soon as you let me on the PR bond, I signed right up for therapy with Blooming Minds. I got a great therapist, Ashley, who's amazing. She was sick. I was supposed to have another date Monday. She's sick, so she rescheduled for the 25th, and I told her everything and how my wife wants to join, and she thinks it's awesome, and we're close. She kind of based it off from, I had like 12 sessions in 23 and early 24. I signed a thing for them to give the records to her, and so we've kind of continued from there. And as far as what I want to say and what I've learned, you know, I think like my wife just said, we had a high stress and our communication with each other wasn't where it needed to be, and it led to this situation and the pain that it's caused my family and my wife is hurt.
So what? I mean, the situation, we have a child vomiting, the sheets go into the lot, if I remember correctly, sheets go into the washing machine. I mean, it happens when you have kids, right? We get into all sorts of things. And your phone ends up in the washing machine, I think. And you get really, really, really upset. Well, what would you change about that day today? And how would you cope with the stress of that?
The phone was part of it, if I remember right, but it was things that both of us were saying back and forth. And I've learned to take a step back and not react instantly in anger, and learn that it's okay to be angry with your significant other, but it's never okay to degrade them and say really hurtful things. So my main thing that I think I've learned is the communication aspect, and taking a step back, walking away before resulting to anger or letting something escalate.
And with the 16-year-old, I know that's stressful. Let's suppose he walks in the house and there's a problem. Are you able to call CMH or 911 rather than taking things in your own hands?
Oh, absolutely. Yeah, there was most of the problems, the severe ones have been since I've been gone. It was at the beginning of
But it's
his.
foreseeable he'll come home, see you, and that things may escalate.
Correct.
And so do you feel that you have the tools to de-escalate yourself, walk away, do what you need to do?
Yes, Your Honor, absolutely.
Previously, I forfeited the weapons. You understand that you are not eligible to have weapons, correct?
Yes, I do, Your Honor.
And you haven't, I mean, you relapsed in 2025. How are you dealing with not just domestic violence, anger? Are you also dealing with substance abuse with your therapist?
Yes, but it's more centered around what caused that relapse, and it.
That's all part of it, but it's
Correct.
all wrapped into that?
Yes.
All right. Don't make me regret this, sir.
Honestly, I want Your Honor.
I deal in evidence.
Well, I'll show
People
you.
promise me all sorts of things.
I'll show you with my actions.
Yes, I hope you do. I'm going to sentence you to 2 days jail, with credit for 2 days jail. And you'll pay crime victims assessment, the amount of $130 and a $68 state cost. As well as a $50 state cost for misdemeanor. How much time do you need to pay that money? It's 168.
Before I leave, Your Honor.
Great. You have 42 days to appeal to request appellate counsel. Don't be back before any judge again. Things won't go well. Go take care of your family. And continue in counseling.
I will. Thank you, Your Honor.
Do you acknowledge receiving your appellate rights? 42 days to appeal to request appellate counsel.
Yes, Your Honor.
All right, escort him downstairs to the clerk.
Thank you, Your Honor.
Thank you, that's all. The no contact order is lifted.
In the tethers.
The teller can come off today.
Okay.
Case is over.
Thank you.
Thank you. Good luck to you, ma'am. But ma'am, if you need to dial 911 or call CMH, do it.